Get ready. Start. Heard Sri MP Devnath, advocate assisted by Sri Nishant Misra, advocate for the petitioner, and Sri Sambhu Chopra, learned counsel for the respondents. Stop para. Petitioner had approached this court earlier by means of civil miscellaneous writ petition within bracket tax bracket close number 924 of 2011 in the matter of consideration of his application made under section 35F of the Central Excise Act with the allegation that various judgments relied upon by the petitioner for establishing his strong prima facie case had not been considered by the commissioner within bracket appeals bracket close customs central excise and service tax Allahabad while deciding his application for waiver titled as stay application referable to section 35F of the Central Excise Act. Stop. Such writ petition filed by the petitioner was decided by this court void judgment dated 11th July, 2011, and it was held that the tribunal should have considered the judgments relied upon by the petitioner in support of his prima facie case. Stop. With reference to the division bench judgment of this court in the case of ITC Limited versus Commissioner within bracket appeals bracket close custom and central excise Meerut first reported in 2005 within bracket 184 bracket close ELT 347 within bracket all bracket close specifically paragraph 35 it was observed that if the SSC has a very strong prima facie case covered by the earlier judgment of tribunal of court of law then the issue of the financial difficulties is not of much relevance. Stop. Para. Accordingly, the order of the commissioner within bracket appeals bracket close was set aside and he was directed to reconsider the waiver application termed as stay application. Stop. In light of observations made in the judgment of this court as well as in light of the division bench judgment of this court in the case of ITC Limited within bracket supra bracket close. Stop. On remand the commissioner within bracket appeals bracket close has reconsidered the waiver application referable to section 35F of the Central Excise Act and has disposed of the same under the impugned order dated 9th September, 2011. Stop. The SSC has been directed to deposit 50% of the amount of central excise duty demanded along with penalty imposed within 2 weeks of the receipt of the order to report compliance within 1 week of deposit. Stop. Appeal has been directed be listed thereafter. Stop. In case of non-compliance of the conditions so imposed, it has been directed that the appeal shall stand dismissed. Stop. On behalf of the petitioner, the order impugned is being challenged on following grounds. Stop. Para. In respect of earlier assessment year, the tribunal had granted 100% stay of the deposited amount, such order of the tribunal should have been followed in toto by the commissioner within bracket appeals bracket close in view of the law laid down by the apex court in the case of Vishnu Traders versus State of Haryana and others reported in 1995 supplementary within bracket 1 bracket close SCC 461, Commissioner within bracket appeals bracket close has misread the judgment of the tribunal in the case of Mayo India Limited versus CCE, Aurangabad reported in 1999 within bracket 113 bracket close ELT 1036 within bracket T bracket close there has been complete non-consideration of the judgment of the apex court in the case of Pawan Biscuit Company within bracket P bracket close limited versus collector of Central Excise, Patna, reported in 2000 within bracket 120 bracket close ELT 24 within bracket SC bracket close stop. Learned counsel for the petitioner made an attempt to take the court to the various agreements executed between the petitioner and the loan licensees for establishing that the loan licensees were manufacturers in their own right and they were not performing the job work on behalf of the SSE stop. Therefore, their turnover was not liable to be clubbed with that of the SSE stop.